So my background is I've worked on probably 150 40Bs, and I like to say I've worked both sides. I've represented ZBAs on a majority of those, or advised ZBAs. I don't really represent them. And on the others, I've been a consultant to developers of 40B projects. So I'd like to think I understand both sides of the 40B business. Today, this is a general overview. The only rule is I can't talk about specific proposed projects. Those are going to come before the ZBA. That's going to be the forum through the public hearing process where you can make your feelings known, ask questions on those projects. We do have a handout, and are there any more? Do any other folks need them? And Erica is going to tell us where they're posted.
So when you're on the town website, then you go to government, and you can go to agendas and minutes. If you click on that, it'll bring you to all of these. But you would just go to Board of Selectmen, find the meeting, the agenda packet for today. You would click on that, and you can get to it. It's also, if you go on government, under the 40B page, and we've got today's presentation. We've got information also from town council.
Great.
So that can be downloaded.
Okay. And town council Alana Quirk is here from Copeland and Page. And if there are any questions that are more legal than I sort of feel qualified to answer, I'm going to call on Alana to answer those questions. What most people sort of want to know to begin with is, where does the town stand in terms of 40B? So if you go to the second from the back page of the handout that you have, and Erica's going to post it. Back one.
Sir, which handout?
There were some handouts. There was a package.
It says general overview on it.
General overview at the top.
Thank you.
Go to the back and flip back a couple pages. Because this is really the guts of 40B. And I want to walk you through that. Might be easier just looking at the spreadsheet, or if not, you can look at the screen. 40B's been around since when? 1969. And what 40B says is that a town has a requirement to meet certain statutory minima. And if it doesn't meet those, or if it doesn't meet one of those, a developer has the right to ask for waivers. The technical term is exceptions to any and all local rules. So that's basically what 40B is about. And the minimum that most people are familiar with is 10% of the year-round housing units. There are actually two other minima. One of them is if a town has more than 1.5% of its land area occupied by qualified affordable housing, then it also satisfies the local or regional need for affordable housing. But the one that really counts for Nantucket is the 10% number, and that's true for most communities in the Commonwealth. So we begin with the latest decennial census, and that says that Nantucket has 4,896 year-round housing units. The number of qualified units that are included by DHCD on the SHI, and that stands for Subsidized Housing Inventory, at this time is 121 units. In other words, you've met 2.47%, or about a quarter of your 10% number. So therefore, a developer has the right to submit a comprehensive permit, and that comprehensive permit could not be summarily denied because the town has met its statutory minimum of 10%. The number of units you would need is 490 units, which is simply the 10% times 4,896. Deduct the 121, and you'd have 369 additional units you would need if you counted the units that are under production at Sachem's Path now. And Sachem's Path is a 40-unit home ownership project with 10 units affordable at 80% of area median income. And if you just assumed that the 7 Surfside development, which is currently before the board, if that were approved, even though there's only one technically affordable unit there of the 4, because it's a rental development, it's treated differently than home ownership. So all 4 units would count. That would reduce the gap in terms of the units you need to meet 10% to 355 units. So that's really the critical number here, 355 units. If you had that, you could deny any comprehensive permit, but you could also approve a development that you thought was a good development for Nantucket. And obviously the town would have leverage on that. Until you meet the 10% or the other 2 statutory minima, which is very unlikely, the developer clearly has the leverage on a 40B development. It's designed to do that. It's designed to create affordable housing units. So that lasts until the next decennial census. With the next decennial census, there'll be a new count of year-round housing units. It's likely that the 4,896 units would increase. So you're never fully protected once you get the 10%. You would want to have a plan that shows how you can sort of maintain that protection so that the town maintains the leverage. Now, there are some incentives that have been created by the Department of Housing and Community Development for towns. And they're geared to encourage the town to prepare, approve, have approved by the Planning Board and the Board of Selectmen a housing production plan. Nantucket had an approved housing production plan. It needs to be updated. It is being updated as we speak. And it's important to have an approved housing production plan because the incentive says if you produce at least 1/2 of 1% of the year-round housing units, you will enjoy a 1-year period during which you could deny any comprehensive permit proposal. And the developer would have no right to appeal that to the Housing Appeals Committee. And that number is a pretty small number. That's only 25 units. And if you did twice that, or 49 units, it's actually the 1% of the year-round housing units, you would enjoy a 2-year period during which you could deny a project. But what this really does, it gives you some negotiating leverage to work with the developer to shape a project that might better satisfy your objectives here in Nantucket. So developers care a lot about these numbers, obviously. When I work with a developer, this is the first thing I do. I say, where do we stand? Who has the leverage? And it's therefore important for you to understand that also. If you do not have an approved housing production plan, you would have to create, i.e. approve, a project that creates at least 2% of year-round housing units in order to get just a 1-year period. So again, that's where the housing production plan becomes important. It gives you sort of more bang for each unit that you create. Any questions on, and feel free to ask questions here.
When was ours last updated? Who prepares that?
Good question. Technically, it has to be approved by the Board of Selectmen, and the planning board, and I believe that is the plan. Who's going to prepare it here, Eleanor?
Well,
Who takes
yeah.
the lead? There's a consultant who's been hired, Judy Barrett, who's experienced. I know Judy, and she's working on it now, I believe, as we speak.
Yes, yes.
So that what you want to do is you want to make sure you want to get that approved prior to a decision on any large comprehensive permit project. Question?
The decision is the operative date, not...
If, for example, I worked with a developer, and we knew that the town had just had a project before it, that if it were approved, and if the town had an approved housing production plan, then we would be facing a 2-year delay. And the project was approved. Well, the housing production plan was approved, and the project was approved the next day. So that's the critical date. So as long as that plan gets approved prior to the decision, those units can count in terms of your plan production progress. However, if an applicant has already submitted an application prior to the date that you reach any of these safe harbor guidelines, they're not affected by your attainment of those safe harbor guidelines. So as a developer, we're always rushing to submit our comprehensive permit application, get it stamped in prior to the town meeting any of those requirements. Any more questions?
If the housing production plan is revised, put into place, let's say in the relatively near term, would Sagem's Path and 7 Surfside count against towards that threshold?
No, because it's only the year in which they were created. And Sachem's Path got its original approval a while ago.
So it's the approval date, not when the units, for instance, are built.
Right. And you only get to count them once against your planned production goal. You can't say, well, we approved Rugged Scott, now known as Beach Plum, a long time ago. And it's just getting renewed now. You can't count it again. You would have been able to count it 8 years ago, whenever that got approved. So it can get a little tricky, but that's why you have folks like Alana and me to advise you on that. So I know part of the reason some of you are here is that there's some proposed fairly significant 40Bs in the works. You need to keep track of where you stand on that housing production plan.
How often does the housing production plan have to be updated?
Every 5 years.
I think the one we had in place, put in place in 2009, expired.
It just expired in August, I believe.
August of 2014.
Right.
These numbers of the eligible housing include Section 8 must have.
No. Section 8 does not count.
That's subsidized housing.
That is subsidized housing. In order to be listed on the subsidized housing inventory, the rules are there has to be a regulatory agreement that assures the units will be affordable for a period of at least 30 years. There has to be a affirmative fair housing marketing plan used to rent or sell the units, and the units have to be restricted to households where the household income is at 80% or less of area median income, and the rents or the sales prices have to be set in accordance with 40B guidelines. And that basically says the rents have to be affordable to qualified households who would pay no more than 30% of their household income for rent or for housing costs if it's a for sale project. Any other questions? for sale housing, once you qualified, it's your house. So there is no ongoing income recertification on for sale housing. For rental housing, there is annual recertification required for income based upon the household size, and all household income has to be included in that calculation. You're allowed to remain in that unit until the household income exceeds 140% of the 80%. At that point, you can begin to pay market rate rents or leave, because it's no longer going to be treated as a qualified affordable housing unit.
So the follow-up is a deduct up above on the list?
It's not a deduct. The developer would need, again, we're speaking only about rental developments, the developer would have to make the next available unit an affordable unit.
Even if it had not started out?
Even if it has not. So in rental housing, the units are fungible. What may be an affordable unit today, household income goes up, somebody has a new partner, income doubles, they no longer qualify for the affordable rent, but they want to stay there. So the next available unit, the next available two-bedroom, becomes that affordable unit. And in rental housing, there's always turnover. You do not lose that unit. There's a statutory requirement for 40B that at least 25% of the units must be affordable units. So the developer has to comply with that.
Does the state monitor that over time, year over year, to make sure that, this is rental obviously, that the 25% threshold is being met?
There are two monitoring agreements in the 40B world. One is for compliance with the limited dividend restriction. For a developer, there are a couple very good things about 40B, and there are a couple things that are sort of the cost of doing a 40B project. The best thing, of course, are the zoning waivers that allows you to ask for a waiver of any local rule. The cost of doing a 40B, what the public benefit is getting the affordable unit, and also the government places restrictions on the amount of profit that the developer can make in a 40B development. If it's a for sale development, your profit is limited to 20% of your approved cost. If it costs you $1 to put the unit in place, your maximum profit would be 20 cents. For rental housing, it's a little bit more complicated, but for limited dividend entities, your profit is limited to a cash distribution not greater than 10% of your equity. There is a fairly generous definition of equity in 40B developments and in most affordable housing developments. Based upon my experience, that limited dividend restriction has never been an issue for developers of rental 40B developments. The returns are not that great, and the definition of equity is pretty generous. And during each 5-year period following the initial establishment of equity, the equity number at what's known as cost certification, you can reappraise the property. And if property values are going up, and if equity is defined as the difference between project value and the debt on the project, equity normally will increase. So that's not really an issue. For certain for sale projects, when you hit the market right with the right product, most importantly at the right time, proceeds could exceed 20%. But you're limited to that, and that money comes back to the town. As I always tell my ZBA clients, don't spend the money. It's not likely that you're going to get that money.
A quick question for you. If a developer proposes 100 homes in one of these, and 25% have to be affordable, that puts 75 houses back into our overall housing count.
Right.
Is there any way we can force them to give us 10% of that 75 houses into the affordable housing to balance that equation out?
No, the best thing you could do, remember, at least on the 40B project, you're getting 25% of 100, so you're staying ahead of the 10% curve. What some towns have done is have inclusionary zoning, which says at least 10% of any project of a certain size must satisfy the requirements to be listed on the 40B inventory. I'm working on a major project in Burlington now with a developer. They're going to get approvals, but the town says at least in its market rate housing, at least 10% of the units. So they just want to sort of stay neutral on that. You could not require a developer to increase the percentage of affordability beyond 25%. There was a recent, relatively recent, very important SJC decision known as the Amesbury case, which defined more clearly the authority of a ZBA when it comes to making conditions on the granting of a comprehensive permit. And they said there are housing agencies involved with 40B. So I'm going to walk you through the basic steps on 40B. They're the ones who should be making the housing policy decisions. One of the housing policy decisions is the percentage of affordable units. You could negotiate with a developer and say, if we do that, we would like to get more affordable units. In return for that, we'll do this. The town's been very generous with CPC funding. And that might be something that you would want to do. And you would expect, hey, if we're using a lot of town money, we want to maximize the bang for the buck on that. Now remember, with rental developments, you don't have to worry. Once you get to 25%, you can count all the units. So your question was phrased correctly. What could you do on affordable units to get more bang for your buck? Ed?
When do you also negotiate, let's say, density with regard to extra? I mean, anything is open to negotiation.
Everything's 40Bs are open to negotiation. Whether they'll be successful or not is the question. But if the most important thing for a developer, and I know we have at least one developer here, very often is timing in the process. And if interest rates are good now, if the market's good now, if you know there are other 40Bs coming around the corner, then developers are always interested in getting a decision as soon as is reasonably possible. So that gives you a little leverage. But developers know the rules. They have good attorneys. Alana at Copeland & Page has worked on many 40Bs. She knows what will get sustained at the HAC and what the HAC will say, look, that's not the way it works. You can't do that. Alana, do you have anything to add here?
Only that I agree with, essentially everything that you've said. The thing that the town has in its back pocket is speed and certainty. And so as you go forward, having transparency in the process so that the abutters feel welcomed in the process by the ZBA to come in and give their concerns and try to itemize them, try to really drill down into what those concerns are and have those be the points of negotiation. That's the time when the developer is most willing to come to the table and say, well, ZBA, you're asking me, the developer, to give the following things in order to satisfy these neighbors. I only have so much money, so much time to give. If you zero in at the beginning of the process on what it is that is of maximum concern to the abutters, that's how you can move the negotiation forward, I think, as effectively as possible. And one of the things that is very important at the outset of the proceeding is for the ZBA to communicate very clearly to the abutters what the standards are, which is why Ed is here, why I've given, documentation as well about what the various standards and rules and deadlines are, so that everyone knows how the process works, where the pitfalls are, where the negotiation points are, so that everyone has some certainty about the process and an understanding and a confidence about the process, which is why I think the town manager and the Board of Selectmen wanted to make sure that they had this kind of presentation today, so that this would begin that dialogue with the boards, with the abutters, with everyone, and really a worthwhile thing to do.
I'm going to get to your question in a minute. Just to reinforce that, the board recently reviewed Sachem's Path, a request for modifications. And the board probably exceeded its authority under Amesbury, but I encouraged the board to do that because I said the Nantucket Housing Authority is providing the land, basically at a very low cost, if anything, and your town CPC funding is making a huge contribution to that project. And therefore, that gives you license to ask for a little bit more. And that, pretty obvious. If you're making a contribution, you can get something for that.
You may be touching on this later, but I just, for my own personal understanding, can you walk through the time frame? I mean, if the application goes to the ZBA.
Okay, why don't we go? Let me cover one thing before that. Let me just walk you through this. 2 hours is not that long a time. If you have a handout, or when you go to the web, let's finish this, okay? There are a few more numbers here that are important in Nantucket. DHCD has also enacted regulations which limit the maximum size of a project based upon the number of year-round housing units. For communities with 2,500 to 5,000 year-round housing units, that maximum size is 200 units. So you shouldn't see a project larger than 200 units in Nantucket. I know you're all saying, wow, that's still a pretty big project. If the number of year-round units go above 5,000, that number, which is probably likely with the next census, that number is going to go up to 250 units. Now, the next number is related to real estate economics, and it's related directly to the cost of engineering, getting permitted a private package treatment plant, sewer treatment plant. And what DEP says, if the total gallonage created by a development exceeds 10,000 gallons per day, the developer has to do a private package treatment plant. And that, you're talking about probably at least $1 million. And it also has a pretty significant ongoing operating costs. Therefore, very often you'll see developments that are either right at the 90 bedrooms, because 90 times 110 brings you just under 10,000 gallons. If it's a senior housing project, there's a different benchmark used for that, which is 150 gallons per unit. So that's why I have 66 units. But I've seen a lot of 44-unit, two-bedroom units. So that's 88 times 110 gallons per bedroom under the 10,000. So if you have to do a treatment plant, then you want to go big, because there are certain fixed costs, capital costs, and operating costs. So if you're near that 44 number, you sort of keep it so that you're below that threshold. And of course, ideally, what everybody wants to do is to be able to tie into a public sewer system. There's no match for that. Okay, now let's go to your questions, but let's go back to my outline. And I'm just going to... That's it. Okay, so some of you have this. All I did at the beginning of this was to list locations on the web that have, in my opinion, the best information on 40B. And I've listed them here. You've got DHCD, and that's where you can actually see copies of the subsidized housing inventory. The Housing Appeals Committee, that's useful because you can get the actual documents. You can get a copy of the statute, you can get a copy of the regs there. And for those of you who would like to, you can read all of the prior HAC decisions. That's something I would never do. That's something you pay lawyers to do. And if I did read them, I'd never read them correctly. And Mass Housing has a good site, particularly in terms of cost certifications. So in addition to listing those, I've printed the home pages of each of those so that you can see what kind of information is available there. Okay. Other places to get information. When I work for towns, very often, most often, I get paid through a third party. I like that because it gives me some degree of independence. And that's Massachusetts Housing Partnership. And they award technical assistance grants, normally $15,000 the first time and then $10,000. Nantucket's already tapped that well a couple times. So I think you're trying to get more money for some of these upcoming. And also, ZBAs have been successful in asking developers to provide funding for services like mine. If the developer thinks that the advisor is there to facilitate the process and remains objective in terms of his advice. You can always find someone who will say yes to anything. You can find people who will say no to anything in this business. That's not who you want. You should visit other developments, but you've got some good 40Bs right here. And you can look at other comprehensive permit decisions. But again, your board now has been through a few of these. You're fortunate to have a board that understands it and have at least a few members who have been through several of these 40B developments. Okay, let's go to the basic steps in the process. And then I'm going to get into the detailed timing steps. And I think I've done a pretty good job of outlining that. And my guess is, I haven't looked at it yet, but Alana's handout, which will also be posted or has been posted, will repeat what I said. So the first thing you have to do, if you're a developer and you want to do a 40B development, is one, you check to see if the town has met any of those statutory minima. That's the first step. That's the due diligence. If a developer doesn't do that, you don't want to do business with that developer because he or she's probably not that smart. Doesn't know that much about it. That's just due diligence 101. You have to then apply for what's known as a PEL, a P-E-L. It's a project eligibility letter. You have to submit an application that explains who you are, who the development team is, where the site is, how you control that site, either through a deed or a purchase and sale agreement or an option or a lease. And you have to describe what it is you're going to do, and you have to submit a pro forma. And you've got a number of places you can submit that. The most common ones are Mass Housing Partnership Fund, or DHCD. I listed Mass Development, but they're really focused on larger projects financed with tax-exempt bond financing. There haven't been any of those, to my knowledge, here in Nantucket. It's probably not likely.
Sorry. If an applicant submitted their PEL application to the Mass Housing Partnership, can you still apply to them for grant funding?
Yes.
Or technical review?
Yes.
Okay.
Because technically the town selects the developer, selects the consultant. They don't select this. They have a stable of folks like me. You get to pick whom you want. And I think that's how they get around that conflict.
There's no conflict
That's how they get around that conflict of interest. So the project, in the project eligibility letter, the housing agency, which is considered the expert in these matters, has to make certain findings. They have to make a finding that the developer is qualified, that the site is suitable for housing, that, and this is one where it really is more gray, that the design is appropriate for the neighborhood. And that's where the arguments really come. Rarely is there an argument about the developer's qualifications. The pro forma, the Pell agency has to make a determination that the project appears to be economically feasible. Okay? There usually aren't arguments about that either. Most arguments are about density, design, and traffic. Everybody's always concerned about school-age children, but towns have learned that when you get to the HAC, there's no argument about that. You cannot use an increase in the number of school-age children to sustain a denial of a comprehensive permit. Anybody, any town that's well advised acknowledges that, and that's the end of discussion. So once a developer, with a project eligibility letter, part of that process is when a developer submits that, it has to submit simultaneously a copy to the town, and the Pell agency sends a letter to the town that gives it 30 days to submit comments on the proposed development. So it's very important for you to make those comments within that 30-day period. And Alana's been involved, I think, a little bit in terms of advising the town on 30-day comment letters. One comment that Elena made was, you need to pick the real issues. Don't waste your time arguing about school-age kids. It's not going to get you anywhere. Focus on the real issues and try to pick them off one by one. The ZBA, when I've worked with them, always has an agenda, and they say, here's what we're going to talk about this next meeting. We're going to talk about traffic, or we're going to talk about the civil engineering, or we're going to talk about design. And that's the orderly way that public hearings should proceed. And you try to sort of knock off those issues. Traffic's a good one to do early because the number of units normally will never increase. And the traffic study is primarily based on the number of units, although there were some safety issues in terms of the geometry and sort of where the roads came in and out of Sachem's Path, which were reviewed carefully by the board. But normally you can do the traffic study, and by doing the traffic study, the developer submits a traffic study. The board has the right to ask, to tell the developer that it wants a peer review done. Then it solicits proposals, and the developer is obligated to pay reasonable costs for a traffic study. So that's where you get the expertise that you need to review that traffic study that the developer has done. And again, most good developers know that traffic is a public safety issue. It's one of the few ways that a project can be denied and that denial sustained. But I have to tell you, and I always get in trouble when I say this, traffic volume has rarely been an issue on all of those 40Bs I've worked with, because the developer normally does those studies beforehand. Traffic geometry, for example, there are a few cases, Alana would be familiar with them in Waltham, where the grade of the road and the shape of the road created a public safety issue. That project was denied, and the HAC supported that denial. But rarely has traffic volume per se been grounds for denial. So once you get that project eligibility letter, I call that the ticket that allows you to submit a comprehensive permit application. The comprehensive permit hearing process can take as long as 180 days or longer if additional information is needed and requested from the developer, and the developer grants extensions to that period of 180 days, which is technically when the closing of the hearing, public hearing, should occur. Once the comprehensive permit is granted, and assuming no appeals, which is sometimes a big assumption, then the developer has to get final approval. Most folks don't understand what final approval means. Remember that 40B is based upon preliminary information. It's basically a zoning approval. At final approval, the developer has to go back to the project eligibility letter agency, explain any differences, any changes in the project that have occurred since the agency awarded that Pell. And in addition, the agency wants more definitive information on the design, the cost. They want to see actual written financial commitments. They want to make sure that the project is ready to go. They want an affirmative fair housing marketing plan. They review that carefully. They're going to approve that. And at least at Mass Housing, there's at least a 2 or 3 page list of the items that have to be submitted to get final approval. Most boards will say no building permit shall be issued until the applicant submits evidence of final approval by the subsidizing agency. The other critical part of final approval is the execution of the regulatory agreement. The regulatory agreement is I'm going to call it a boilerplate form, which is one of the primary control documents for 40B developments, which spells out the affordability requirements and the limited dividend restriction requirements. And that's what protects a town that, in fact, is going to get the 25% of the units affordable. So that's really a critical step in this process. Once you get the final approval, then you get your building permit, you build the project, and the final step is cost certification. Cost certification is where you submit as a developer all your costs. You establish the equity, or you establish the dollars that have been spent on a project, and therefore your profit would be limited to 20% of that amount. Now, if there's an appeal, that obviously can stretch it out. If the applicant is denied a permit, or if the applicant is granted a permit but feels that the conditions in the permit make the project uneconomic, and that's a defined term, then the applicant can appeal to the Housing Appeals Committee. And it's fair to say, if it's a reasonable project, the Housing Appeals Committee is likely to be supportive of the applicant and not the town. There are some instances where that hasn't worked, but by and large, and that's what makes the job of a ZBA so difficult. And I like to compare the tasks of a planning board member with the task of a ZBA member. If it's just a sort of normal review, not a special permit, there are rules that are black and white. And if the end of the road, if the dead-end road is more than 400 feet, you can deny it. And there's no appeal of that. Those were your rules. You didn't meet it. Special permit, there's a little bit more, I think, sort of opportunity to shape a project, but still some pretty well-defined limits. With a 40B project, the ZBA is always charged with sort of the best play for the town. We can work certain things out with the developer now and negotiate, but the developer, if it goes to the HAC, if there's been no negotiations, a lot of ill will, they can start over again, and whatever nice things they thought they were going to do, those could be out the window. So that's the balancing act that the ZBA has to do. Ed?
Now, upon appeal, let's say it goes to that extent. Can the developer just revert to what he or she or whomever wanted, in other words?
Yes.
Any of the negotiated points
Out the window. Because remember, the board is charged with reviewing the application that's been put before it. So when I work with developers, we say, look, our original application is what's before the board. Here's what we'd be willing to consider. But it's a de novo hearing. What's a de novo hearing, Alana? Start all over again.
So I want to be clear on this because the ZBA works with the developer and they come to an agreement between the two parties. If a neighborhood appeals it, that agreement's gone and they go back to their original request.
They'll say, hey, all that time that's been incurred, and remember, neighbors have two venues to appeal to. They can appeal to the land court or the superior court. And then there can be appeals of those decisions. So I've worked on some deals that have been stretched out 3, 4, 5 years through litigation.
But that's not, the neighbor's appeal is not a de novo appeal. It's only when you go to the housing appeals act.
Alana, I'll ask my legal expert here.
Still de novo.
Still de novo. And what developers will say is, look, I was willing to do that before. I've just spent $100,000 on legal fees and spent a year. I can't do that anymore. We're back to what I said I was going to do originally. And again, 40B is about negotiating and trying to maintain a reasonable relationship with the developer. There are plenty of good developers who understand that. There are developers, it's fair to say, I've done it myself, you come in with a pretty aggressive proposal and you try to leave some room to negotiate.
I feel like Ed is not blowing his horn loud enough because he has another role to play in all of this that perhaps we should talk about. One of the questions was, what are the deadlines when you're dealing with the public hearing? And so the first thing is, you know, the public hearing has to open within 30 days. As Ed said, close within 180 unless you have a different deadline that's agreed to, make the decision within 40 days, and then 14 days to file the decision. But in between, while the public hearing is open, one of the things that if I'm counsel, if I'm talking with the ZBA, once the board gets to a certain point, I'm going to have a recommendation that they hire a consultant. And that consultant, you know, likely would be Mr. Marchant. He's a pro forma expert. Because part of the negotiation process, as I mentioned at the beginning, is to know what the standards are. And the standard is that in the event that the developer comes forward and says, look, there are no local concerns out there, this development is fine, you know, I'm asking for, you know, minor waivers, just give me what I want. The ZBA and the neighbors look at it and say, we do have local concerns, and here's what they are. And we believe that these local concerns outweigh the regional need for affordable housing. And once that discussion happens, in the event at some point, the ZBA and the abutters come forward and say, gee, here's the laundry list of conditions or concessions that we want from the developer. The developer then can say yes to all of them in the event that it's going to create speed and certainty. That doesn't always happen, doesn't often happen. Oftentimes they will say no, that one or more of the conditions would render the project uneconomic, as Ed said, and then that's the time when you hire a pro forma consultant, because then that's the time when the ZBA has the ability to hire someone like Ed to come in, look at the pro forma, and make a determination as to whether the conditions, the requirements that the neighbors have asked for, that the ZBA think are important, whether they do indeed render the project uneconomic. And that's where his expertise as an expert in the economics of these developments comes into play, and that is an extremely critical role.
And although I have done that, that's the last resort. I like to work with boards during the hearing to see if there can be a negotiation that can create a project that, if people aren't happy about, they're less unhappy about than what was originally proposed.
In your experience, Ed,
Yes.
you've had projects where you've had neighborhoods that were adamantly against these projects. And the back and forth went, they went back and forth, CBA, the developer, they came to a compromise, they were happy.
Yes, I've had.
How do you keep the neighbors from appealing it so that it doesn't throw all that work?
I recently worked on a project in Littleton, Mass., and the neighbors were well organized. They were represented, not by an easy lawyer, in my opinion, who shall remain nameless, but they agreed. They entered into a formal agreement and said they would not appeal the decision. Now, that doesn't mean that someone 4 streets down who can argue that they have standing wouldn't appeal, but that's worked in more than one project that I've worked on. And it's really sort of, if people are going to negotiate in good faith and they're represented by reasonable counsel. There's some counsel out there that I have to tell you, they've made their business by delaying projects as long as they could in hopes that they would never surface. And I think retaining counsel like that is dysfunctional. In fact, we had an experience like this in Nantucket, I think, where sort of at the end of the hearing, someone came up and said something, and the board said, look, it's just too late. Time and place for that was about 7 months ago. So again, reasonable negotiation is possible, I think, in 40Bs. And if you can't, then at a certain point you just take a stand and you say, we know the consequences, but here are the conditions, and we'd rather fight than approve it as it is. And you get into a contest, and then knowing that the time will eat up a developer, particularly if the developer doesn't have good site control. If the developer owns a site and has owned the site for a long period, that's not going to work. But at some point, I represented the town of Yarmouth. It's one of the few times I told the board they should deny the project. Why? Because it was located in a neighborhood that was a perfectly good small lot industrial zone with active users. And it wasn't on the edge of that site, it was in the middle of that site. It was lousy for the people who'd be living there, and it was unfair for all those sort of hard-working industrial tenants there. They didn't need housing next to them. But that's one of the few times. There was one other instance where Copeland and Page was counsel and I was advisor, where I just thought the building was way out of scale in terms of the existing neighborhood. But normally, I think you can negotiate these things.
And is there any upside or downside to reviewing 240Bs at the same time? Is there any leverage that we have with that, or are the developers more concerned about teasing local board to get it?
The only leverage you have on 40Bs is sort of what happened to my client, where there was a 40B. We were in the wings. They knew we were in the wings. They went out of their way to approve that other project in a more timely manner than they would normally have, so that they could get that 2-year delay. But we hadn't submitted yet. If the 40B's already submitted, has no impact. Has no impact on any of those safe harbor requirements. Let's go to Mike.
Assuming an appeal by neighbors, do the neighbors have a risk in losing the appeal and the judge actually doing away with all the conditions or some of the conditions that the ZBA put on the applicant?
What's your experience been on that?
This assumes the neighbor's appeal, not the applicant.
So it assumes that there was a grant, and there were conditions, and then the neighbor's appeal. I have to say, I haven't seen a successful abutter appeal like that in my experience. So I've not seen in that circumstance any change in the permit. What happens most often is that the developer will challenge the standing of the various plaintiffs in that case. And it's very difficult for the plaintiffs. There's money to be spent, and not just the complaint, but experts and so forth. It's an expensive undertaking. And so what happens is you may have a loosely formed neighborhood association at the outset, but then when you get to the point of the appeal, they have to make sure that they have at least one person who has sufficient standing. And the rules are quite clear, the case law is quite clear, that a diminution or a claim of diminution in the value of a person's housing as a result of the project is not something that is protected under 40B, and so that does not confer standing. And so that's usually where the argument is, right at the beginning. You'll see a tussle over that. There'll be a series of depositions over to see what the plaintiff's interests are, if there's any drainage impact, if there's actual height involved that's going to overshadow them, that kind of thing. And
assuming that there is standing.
Okay.
It's the appellants. Have you ever seen a judge rule in favor of the applicant and take the conditions off of the applicant?
I have not, in my experience. But certainly, if in an outside exaggerated case, if you had a very tall, let's say, apartment building or condo building, and it was right next door to a single-family home, and those abutters said, well, gee, the town now is going to achieve 10% with this, and so the town was for this, but now I have this thing that belongs in downtown Manhattan right next to me in a single-family neighborhood. In a circumstance like that, they'd say, gee, our garden will never get any sun, and we're never going to see the light of day again. Well, in those circumstances, it would be possible, of course, for the judge to say, the height is too high. There would be the ability, to go in that direction. Yes, sir.
Assuming that the neighbors have standing and they go through the process and it takes a year through the Superior Court and they lose, at that point, can the developer go back to the HUD and say, I want the original project no matter what?
No, they have a comprehensive permit that's already been granted,
So they can't go
Well,
back.
at any point, a developer can go back to the ZBA and ask for modifications to the comprehensive permit. And the board so the developer submits a request for modifications.
I understand. What I'm talking about is
You're talking about the judicial action.
what we said that if the developer isn't happy with the ZBA or there's an appeal, they can go back to the housing authority for the original project.
Housing Appeals Committee.
So
Right.
if the ZBA and the developer come to an agreement, then the neighborhood decides they're going to appeal it. They have standing to go through the process. It takes a year in the courts. They lose. Can the developer at that point go back to the housing authority and say, I want my original project, screw what I had with the ZBA because it's added a year to my project? And
A developer, as I was saying, can ask for a modification at any point.
They probably could,
But
why wouldn't the developer has negotiated it?
well, because he might have negotiated for less units and now he's lost a year and he wants what he
Oh,
originally
yeah,
wanted.
if it ever becomes.
It's conceivable that you could do that, and then the board has to review it again if it's
But not the ZBA will review it.
No. I understand
no.
your question. And the answer is, once the abutter appeal is done, then the comprehensive permit is perfected, and there is not then an appeal to the HAC. And so Ed's point is that the mechanism that the developer then would have would be to say, I need a modification to the permit that I now hold that's been perfected because the delay means that I need more units, or I need something's changed, and so I need a modification. But then they go back to the ZBA to ask for that relief, and then only if they're dissatisfied with the ZBA do they go back to the HAC.
so they remember now. You go for the modification. The ZBA says that's a substantial change. We're going to reopen the public hearing. Once you reopen the public hearing, then you're subject to appeals again from neighbors. But ultimately, if you're dissatisfied with the action taken by the ZBA, you can file another appeal within 20 days with the HAC. So let me get to my detailed list that you had asked about. First of all, in large print, this is the real sort of job of the ZBA. Responsible for balancing regional housing needs with the following concerns: health, safety, environmental design, open space planning, other local concerns. There was a case in Dennis where open space actually won the day, where that was upheld by the HAC. Now, I want to give you the time, and I do a little teaching, and I always say a good question would be to explain what 7, 14, 30, 15, 15, 30, 180, 40, and 20 means. So let's walk through that relatively quickly. 7 days. The applicant submits the comprehensive permit application, and it shouldn't be a surprise because you've already got the Pell, you've already got the 30-day comment letter, you know what's coming. So you tell the clerk at the ZBA, as soon as you get that, make sure we know, because within 7 days you want to distribute copies of that to all your local boards. That's important, but what's really critical is that you must open a public hearing within 30 days of the date of the submission. If you don't do that, you're at real risk of having a constructive grant sort of claimed by the developer. A constructive grant means the ZBA didn't perform in the required time frame, therefore whatever it submitted is approved.
So the application submitted to the zoning administrator, is it on the applicant to take to the town clerk, or is it on the zoning administrator to take to the town clerk and file? Stamp it, file it.
Well, it's filed with the town clerk. You take to both. Whenever I go in with one, I make sure I get that date stamped.
Yeah, so the applicant takes it to the town clerk and then brings it stamped.
Stamped, and then it's your job.
And that's your.
Then if you're a developer, to be perfectly frank, you'd say, well, if they wait for 45 days, that's great, because all of a sudden I've got more leverage.
But you.
I'm going to claim constructive grant, and maybe we'd negotiate something.
So you have, so your countdown starts with the day that it's stamped, filed by the town clerk, and then suppose for whatever reason that legal ad-wise, I mean, this has happened, you can't get it in the paper in time to legally notice it. Can you get an extension?
You can get an.
Right to get an extension?
No, you have a right to ask for an extension.
Right.
Because remember, with the public hearing, you need to advertise, most towns, and maybe it's a 40-day requirement, at least 14 days before. On a recent project I've been involved with, it had to be advertised 2 times, one of which had to be at least 14 days before. So you have to be ready to do that. You also have to notify abutters, and that's why one of the requirements for a 40B application is a list of abutters certified by your assessor's office. And you have to send out notice to them.
So you're saying, I'm trying to figure out who's doing this when you say you.
The town is doing it.
Right, and who in the town? Is that the ZBA?
ZBA. Because remember, the ZBA is the permit granting authority on comprehensive permits. There's a reason we call it comprehensive. The ZBA assumes the roles of all local boards. And very often they're lonely. They're lonely. Planning board says, wow, glad Ed Toole got stuck with this one. Okay? Let him worry about it. Because some 40Bs are no wins. Just no wins. You learn you're never going to make everybody happy. You're just trying to do all a ZBA can be expected to do is make the best judgment, be fair, be timely, make the best judgments it can. And the ZBA is looking for input from all the local boards. Sometimes it's hard to get those written impact. You'll send it a note. Okay, Eleanor might say, look, we're going to have the public hearing opening. We want your comments by X date. And then you have to chase people. Or you try to get a fire chief to come to a meeting, or the safety officer for the police. And if you've got concerns, make them known. That's your right. That's what the public hearing is designed for. And if there are real public health and safety issues, if it's that silver bullet, then you have a right to use your leverage just as a developer has a right to use his or her leverage. So we got the application, 7 days, distribute. You get about 15 copies of it, sometimes 30 copies. Say, we want your comments by X date. Advertise in accordance with the procedures, 14 days. Open the hearing. If you think the application may not be complete, don't gamble. Open the hearing and say, we've reviewed your application. We think it's deficient in the following manner. Put it in writing. Okay, always put it in writing, so that when the applicant comes back and doesn't have the 3 things you thought were deficient, you say, hey, we just notified you. You know, let's move this. We want an extension of that 188-day period. So let's keep going now. 7 days, 14 days, 30 days. Now we have 2 15s. Within 15 days of the opening of the public hearing, you have to notify the developer that you have made a determination that you met one of the safe harbor requirements or one of the statutory minimum. Now, safe harbor requirements, Lana talks about this in her piece. I've got a lot of information here. Safe harbor is primary. Remember that 1/2 of 1% or the 1% or the 2%? Those are safe harbor requirements. If you've met one of those, you make that determination. You give a letter and the evidence or the facts upon which that determination is made to the applicant. The next 15 days, the applicant has 15 days to appeal that determination to the Department of Housing and Community Development, which is the state's housing department. DHCD then has 30 days to make a ruling as to whether or not it agrees with the town or the developer. The safe harbor in terms of the 1/2 or 1% is fairly easy to understand. What the most recent issue has been the 1.5% statutory land area. And that's very difficult because nobody has good data on what the total acreage of the qualified land is, let alone the qualified acreage of the housing. Because sometimes you'll have housing that's concentrated in a certain area, and then there's an extra 10-acre tail on that has nothing to do with the housing. That doesn't count. I've just been involved where I represent a developer in Newton. Newton made that claim on 2 projects. DHCD said they were wrong. The developer appealed that to HAC. It was an interlocutory decision, which is a new word for me, Alana, which is sort of an interim decision. The HAC said, no, we agree with DHCD. You have not met that 1.5%.
We have a number of cluster subdivisions out here that concentrate the density of the housing, but it's over 30 acres of land. So let's say that 25 acres is free land based on the cluster and the advantage to doing that. That land is not included in the...
Is there any affordable housing in any of those cluster developments?
I doubt it.
Right. So I think it's an academic question. Because with 40B, normally they're very dense developments. And if you had all that acreage, you'd build more units. And the land area that can be counted is directly related to the percentage of affordable units. Those same rules apply. If it's a for sale development and you have 25% affordable, you can count 25% of the land area. If it's a rental development, you can count all of the land area. If you had inclusionary zoning with only 10% affordable units that qualify for that 80% subsidized housing inventory guideline, you could count 10% of the units. So that's the 30 days. So then the developer can appeal. Then 180 days to close the hearing. And what I always advise boards is I say, look, if you're not getting the information you need that is reasonable for you to ask for to make an informed decision, don't worry about the 180 days. Tell the developer, look, don't blame us. We asked for this information. You haven't submitted. The information you submitted was not up to par. Give us an extension. And developers will give the extension because they know they were at fault. On the other hand, if a developer gives a couple of extensions and it's clear that the ZBA is just dragging it out, that they've got the information they need, a developer will say, sorry, we're not going to give you the extension. Just make a decision.
The 180 days is not from the initial public hearing. It's from the town clerk filing.
No, it's from the date of the opening of the initial public hearing. So you get that 30-day period during which you're setting up the initial hearing doesn't count against you. In 180 days, if there are not unusual technical issues related to drainage, related to septic, you should be able to make a decision in that time. You should be able to get sufficient information from the developer to make that decision. Now, what happens very often is that plans will get revised. That Littleton project I worked on, which I think the town is reasonably satisfied with, and I represented the town on that one, that went through 3 iterations. And the end product didn't resemble the initial product at all. Again, if the developer is willing to change, that's okay. 40 days from the date of the closing of the public hearing. Once the public hearing closes, you can't accept any more information. So I always advise boards to keep that hearing open until you know you've got a decision that's been reviewed or done, reviewed by the board, got some input, reviewed by the developer, and you think it's sort of a 95%. Because you never know when you might need some additional information. So I advise keeping the hearing open, and I say, the developer's normally willing to do that because you've got 40 days to do the decision. So boards will say, look, we're going to get this done in 40 days, but we want to keep the hearing open. Now, that assumes that you can hold a public hearing and you don't have to listen to the same issues after 180 days. If it's a really contentious hearing, then at some point the board just says, I think everybody's had an opportunity to speak. There are no new arguments. We're just going to close the hearing. Because a public hearing means everybody has a right to speak. So sometimes you have to do that. But rarely have I seen that happen. So then technically you have to do the vote within 40 days. I'm more conservative. I say file the decision with the clerk's office within 40 days of the closing of the hearing. You don't want to miss any of these deadlines. Life's difficult with 40B, but understanding and meeting these deadlines missing these deadlines is inexcusable. You just have to do it. Then an applicant has 20 days to appeal, and residents with standing have 20 days to appeal to those different venues that I just discussed. And then once the developer's work then transfers to getting final approval. Eleanor?
Are residents of standing those within 1,000 feet?
Alana? What do you need to have standing to appeal a 40B decision?
Well, I don't represent the abutters, so I certainly have not had the experience. But I can certainly tell you that the basic case law says that a diminution in the value of the person's home is not a protected interest, so that's not going to give standing. And I would suggest that it's an interest such as, there's drainage that's going to come onto your property. It's going to flood your basement. There's a height issue. There's a buffer issue. There's, let's say you're directly across the street and your driveway is not exactly across the street from the way that's being proposed, so that they will compete with each other in a way that's not safe. That would certainly be an issue. Site distances, those kinds of safety issues are really what are going to drive standing. And increased traffic, as Ed said, traffic is really, it's something that the neighbors really have a concern about. But and they say that dentists have a high suicide rate. I wonder that that the traffic engineers don't as well, because they get up and they say, gee, this is going to have no impact, and no one believes them. And so it's very difficult for them to be put in that position. And so what I always recommend in a situation where the traffic report that's given by the developer shows that there'll be virtually no impact or not something that is going to be dramatic, that it be peer reviewed to give it that transparency, and so that the neighbors and the board both have that comfort and confidence in the fact that, yes, the traffic determinations that are made in the report are correct. And certainly when you have the peer review come in, you can also ask the peer review consultant, what can you suggest that would make this better? And they may say, gee, flatten this curve, or put in this signage, or get these site distances at this particular part of the road that isn't even part of this development but is a problem on this road. Try to get that fixed and get the money for that from the developer, because it helps the developer's project as well. And oftentimes a developer will do that. I had one where they did all of those things. They flattened the curve, and they changed the curve, and they did all of the work on land that they didn't even own, with the permission, obviously, of the owners. So, the standing thing is a dramatic thing for the abutters, and it's very difficult for them to hear, and I appreciate that. And that's why I think the emphasis should always be during the public hearing process to give the neighbors the full opportunity to come in and say what their concerns, what their terrors even are about the project, so that they can be addressed head on. And if there's a way to deal with the developer ahead of time, certainly the Board of Selectmen and the town manager have been very proactive during the comment periods for a number of 40Bs that are out there. They already have these conversations going on. They know, I think, what the concerns are going to be. They've been listening. And so that's really important for the abutters, the neighbors, everyone in the area, to voice those concerns, to put them in writing, send those emails in, so that everyone knows exactly what the concerns are, so that they can be addressed, if possible, up front on a voluntary way.
Who's considered an abutter? How close do you have to be?
Well, really, it's the party aggrieved. Obviously, under 40A, Section 11, the procedural requirements under the Zoning Act are injected into 40B, and so, it's an abutter within 300 feet. But to be an aggrieved party, it needs to be somebody who was harmed. And so, of course, if somehow the drainage, even though you were past that point, if somehow the drainage was going to have an impact on you, even though you were further away and it's going to flood your basement, whereas it's not flooded now, well, then you would make that argument. I'm aggrieved. You're causing some physical harm to my property that's going to cause me problems down the road, not just because I think that, based upon what my realtor is telling me and is willing to sign an affidavit, that the value of my house is going to go down just because this project is going to be there, but some real physical impact, drainage, the height, the buffering, those kinds of noise, lights,
When you say height, what do you, I guess a lot of comments I've heard is, for example, the building's going to be 40 feet, everything else in the whole area is 30. I'm going to see this roof line from my house from 2 miles away. I don't want to look at this. I don't want to see the lights.
No.
That's not a,
No.
it's not a reason.
No. The kind of height issues that I've seen and have seen raised successfully in the past are where there are abutters here, and the project was proposed here, and it was going to be at 55 feet of height was proposed, and I believe we got it down to 42, so that it was more in tune with what would normally be allowed, and so that and we moved it further away. But once you move it back, I'm really talking about a height situation. The the exactly where it's very tight and it's really right above you and looming over you. I believe what the HAC case is. I did have a high case of actually at one point did, unfortunately, Ed doesn't have to do this, but I actually had to read them all, and there were probably about 18 of them, and they talk about looming over, but obviously the further away you get, the more mitigated that is, and the less likely you are to be found to have standing.
And the best way, given what Alana just said, the best way to deal with height is to sort of state it straight on. Ask the developer, are there ways, here are the most sensitive areas. You might even say, look, this back building, if you want to do that 4 stories, you could do that one 4 stories, but we want you to drop a level there. So you really need, I'd like to think, my other business is really real estate, and I've worked with developers directly. You want to take a look and figure out whether there's a reasonable sort of negotiation where that will address some of the concerns about height.
And one thing that I'll jump in is that you can talk to the developer about stepping it back so that there's, let's say it's 35 feet at one point, and then it steps back before it goes up to anything higher. And then if they also do facade mitigation as well with colors and material changes, that can help as well. So there are lots of things that can do.
While you're there, just in that regard, if someone came and said, I want a 5-story building, they don't have a single 5-story building anywhere on the island.
Right.
I want a 5-story building, and I want somebody in the HTC would never approve. What is our standing with the HTC in regards to that?
Well, I think then you're talking about something that is really out of character, with the community, and certainly you have an argument to make there. But you would always have to look at how is it placed. I mean, if you told me that it was on 50 acres and it was in the middle of the 50 acres and it really couldn't be seen from anywhere, that might be something that would be allowed, as opposed to, again, what I keep coming back to, there was one of the few cases where I've seen a project eligibility letter denied. It was for the town of Scituate, and they came forward with a proposal to put in, I want to say it was 10 stories high or more than 6 stories high, and there isn't anything like that in Scituate, and it was right on the edge of the harbor, and DHCD just wrote back no, and didn't even ask anybody, didn't send it out for the comment period. So, I think that there is some sensitivity, obviously, to the kind of thing that you're talking about. Obviously, tourism is important here. It's the lifeblood of the community, and there's a certain feel and look and character to this place that should be honored and protected. And so, again, it would depend upon the circumstances. Yep. Yes. 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 It should be addressed. Yes.
Just going back to the PBL, what's the nature of the municipality's covenants that state, that 30-day period?
It really is designed to address concerns you have based upon your understanding of what's being proposed.
I guess what should the covenants be at that time? Things like
Well, it could be about design, it could be about traffic, it could be about the size of the unit, the massing of the units, the site plan, the buffers being proposed. Anything's fair game in the 30-day comment letters. And normally what the agency does is they accept them, and then when they issue the project eligibility letter, which is more likely than not, unless it's really an unusually outrageous proposal, they will say, we have received the following comments from the municipality. We expect that these will be addressed at the ZBA public hearing. So they sort of kick the can to the ZBA.
But just to add to that a bit, it is a roadmap, though. It's a roadmap for the ZBA and for the abutters to see that the Board of Selectmen have these issues and that they are of extreme concern. And then the developer knows going in, here's where we should start at a minimum. We should be looking at whether it's height or buffering or traffic or setbacks, water, sewer, whatever it might be. It's very important to get those items out there quickly.
Oh, a question here. There was a question?
subsidizing agency, yeah.
Right. Does the municipality need to take that into consideration? Do we make mention of that? Because some of them aren't forwarded to DHCD, for instance, to the DHCD or Mass Housing or Mass Housing Furniture. Some of them are just sent to the local boards.
No, the obviously every board member looks at every comment that comes in, and so obviously each one of them is looked at and considered, and then there's an overall comment that goes out that says, here are what our concerns are, here are what our issues are, here are the conditions that we want to see, here are our concerns. But there's no need to say, and attached here too are a series of abutter letters. That's not necessary.
I'm not thinking that would be a good idea, but just to say, there is, considerable opposition or don't.
There's no harm including that
Yeah.
information in your letter.
Well, obviously, the fact that there may be people who are in opposition or people in favor, ultimately the issue is whether the project meets the criteria in order to either be granted or granted with conditions or denied. And so, obviously when I go to court and I'm defending a decision that's been made on the de novo appeal in a basic zoning case, one of the first things that the developer on the other side will do is say, well, Your Honor, I want to put into evidence all of these letters that were in favor of my development, and I always move to quash and don't admit that, because it isn't a popularity contest. So really, it's not evidence. But if there are specific issues and concerns that are addressed in those abutter comments, of course they're going to be folded into whatever it is that the ultimate comment is from the town. And if there was something in the way of evidence attached, there was a drainage report or some other kind of factual evidentiary piece of information, of course that could be sent along as well.
The actual findings that the Pell agency has to make are listed on page 12 of my handout. For the design-related one, it reads, the agency has to make the finding that the conceptual project design, and they say conceptual because, again, as I stated before, 40B is based upon preliminary information. One of the conditions in a comprehensive permit would be you've got to submit you have to submit actual drainage calculations. You may or may not need those at the public hearing stage, but certainly prior to the issuance of a building permit, you would want to see the drainage calculations. And in some instances, you want to see them right during the hearing if there's any question about site drainage. It says that the conceptual project design is generally appropriate for the site on which it is located, taking into consideration factors that may include proposed use, conceptual site plan, and building massing, topography, environmental resources, and integration into existing development patterns, such finding with supporting reasoning to be set forth in reasonable detail. So that's what the Pell agency is trying to do. They are sometimes, I think it's fair to say, pretty flexible in reviewing the design. So you're going to still have to raise those issues at your public hearing.
Let me ask you this. A developer wants to do a project, and it's not in one of our designated sewer districts, but it's determined that we have capacity in the wastewater treatment plant for these additional units. If the developer wants to run sewer at his expense, do we have to let them hook in? Or do we have to include it in the district? Or do we say, sorry, you can't hook in even though there's capacity there?
I go to my legal expert.
That's a legal question that I recommend be left to the appropriate time and occasion. Certainly you have a special act that relates to the sewer district, which says that the sewer district is put together by a bylaw that's approved by town meeting, and the SJC stated in 2008 in the Groton case that, when there is a legislative action that is required, well, the HAC can't, substitute for that legislative action, nor can the ZBA, because the Comprehensive Permit Granting Authority is about the granting of permits that the various boards that the ZBA is standing in for have the authority to grant in the first place. And so if there is not the authority for a local board to grant relief, such as the extension of the sewer district, then because it requires a legislative action, then presumably the ZBA is not in a position to grant that relief. But that is for another day, looking at all of the facts and circumstances that exist, if that question should arise in the future.
Other questions?
Just on sort of the financial contributions by the 40B developer to infrastructure and such. Is that a ZBA issue, and who gets involved in those negotiations? I assume they're negotiations.
Okay. Two sides of that. Very often a developer will ask relief on certain fees. ZBAs, I think, wisely say, the Board of Selectmen set that policy. We're not going to waive fees. We're not going to take the initiative as a ZBA to waive fees. If you go to the Board of Selectmen and they support waiving of fees, that's fine. But we're not going to get in the middle of that one. Now, the other side is where you're asking the developer, it's called mitigation. And my experience with mitigation has been diverse. Some projects, developers are willing to provide some funds, particularly if the funding is used, the use of the funding benefits the project directly. A not uncommon one might be a traffic improvement, a deceleration lane, even a traffic light for certain large projects where MassDOT says a light is warranted. You can't just go out and put a light up. It has to be warranted. A developer also will say, look, I'm already at the threshold of being economic. And the definition of economic for a rental project is a project that has a return on cost. And now I'm going to get a little technical, but if you took the net operating income of a project, you take the rents, account for vacancy, deduct all the operating expenses, deduct the replacement reserve, that's your net operating income before paying any debt service. That's the numerator. The denominator is the total cost of the project. If that number is less than the sum of the 10-year treasury, which is now about 2.02, plus 4.5%, that project would be determined by the HAC to be uneconomic. And many projects that come in, and I know this from working both sides, are right, they're close to that 6-7% cap rate range. So the developer is going to say, look, I'm already at threshold, or I'm already actually below that. I can't afford to fund any mitigation projects. On the other hand, I've worked with projects, some of the national developers who are used to paying mitigation fees, who know that very often agreeing to mitigation will expedite the approval process. That it will solve an issue. If that use of the mitigation funds will help solve an issue that makes it easier for a ZBA to reach a decision more quickly, a favorable decision, they might do it. So as I always say, you have nothing to lose by asking. You can ask for any information. You could ask for any mitigation, and a developer can say, that's not reasonable. I'm not going to do it. See you at the HAC. Now, it's not that extreme, but that's basically what developers are thinking.
But the venue is the ZBA, as we all know.
The venue is the ZBA. The ZBA is the special permit granting authority for comprehensive permits, unlike a normal special permit where the planning board might do that. I often conclude any presentation on 40B by saying people focus on the value of the 25% of the units that are affordable, and I argue that the 75% of the other units often sort of offer units that expand housing choice. For example, in a place like Sherborne, where there is a very affluent community, rural, no water, no sewer, no public water, no public sewer. Being able to offer a townhouse building that's smaller in size and by definition smaller in price is a valuable resource for a community. If you could produce housing that offers moderately priced housing for the other 75%, that would be a very good housing policy. However, there's no guarantee. You've got such an, island economies are very different. If you build those 75 units, a developer is in business to make money. That's the only reason a developer is in business. That's what the developer's job is to do. So they're going to sell them at whatever price the market can command. But by definition, if it's a smaller townhouse unit, the price point will still be a little bit lower. A number of communities have been very aggressive to have an sort of offensive sort of approach to defend themselves on 40B. So they've gone out of their way. They've said, you're generating a lot of money in your CPC funds. You should be saying, how can we maximize the value or the bang for the buck on those CPC funds? And you might say, again, rental housing, you get 4 units for every one. You might say, well, if we're going to use CPC funds, let's use them for rental housing. There are others in the community who will say, hey, what we really need is for sale housing. So that's something, and the town's going to be looking for input on this update of its housing production plan. That is a great question, and that's what you should be trying to figure out. You should be asking Judy Barrett, who's been doing this for a long time, explain that to her. See what she can come up with, because she works with communities all over the state. And see what you can negotiate with developers.
I think the key, though, is that you can't use that as an argument to deny affordability.
Absolutely.
So once the 40B is in the queue, you have to stick to the merits of what you can.
Absolutely.
Just to clarify on that, the town had, nice to see you again. The town has a proposal in theory to do some housing adjacent to the site, up to 100 units, give or take rental units. Under this current timeline, our town meeting is in April, which is more or less 180 days from today. If we were to have approved those projects at a town meeting before a 40B was certified, greater than 2% of our housing production plan when it's done in.
Not before a 40B is certified, before a 40B comprehensive permit application is submitted.
Just want to be clear, thank you. Okay, what's that definition of uneconomic for sale?
For sale, if the profit is less than 15% of approved costs.
Considering if the conceptual project design is appropriate, how come it doesn't specify density or its building massing?
Because density is relative. It depends upon what your building type. Is it a single family? Is it a duplex? Is it a townhouse? Is it a garden apartment? What's the site like? What's it adjacent to? Is it adjacent to open space? Is it on a major road or is it on a subdivision road? So you can't, there's no sort of one-fits-all answer for density. You can't say 8. The state used to say 8 units per acre for sale housing. And they realized that you cannot come up with any quantitative standard because every site is unique, and you really have to think about that. they're going to look at the topography of the site. They're going to look at the massing of the buildings. They'll look at the height of the buildings. They'll look at the buffers that are created. As Alana said, if you have the luxury of having a really large site and you can set the buildings back, then they'll say no harm, no foul.
What can you tell us about what it says in 40B regarding clustering too much 40B developments in a specific area?
I don't think that's an argument that the ZBA could use. It's an argument that the Pell agency might use. But let me tell you, when you're at 2.47%, which is low among the 351, pretty low, it's not going to have much bearing. If you were at 9%, and everything was all with this part of the island, you'd say, hey, this is what you say, we have nothing against affordable housing, right? Nobody has anything against affordable housing, just when it's next door to you. We'd like it over here, and we'll support it over here. But at 2.5%, you don't have a lot to stand on, and I'm being very frank here.
Is there any obligation of these where we submit them, where the developers is submitting the permit, these off-island agencies, them to actually come to Nantucket? Is there any obligation that they have to see what is really proposed? I mean, sure, Google Earth works, you can kind of look.
They were just here. They have to conduct an on-site visit.
They do. Okay.
And they will come. They will bring a team, and they'll invite members of the town to participate in that. Ed?
In your experience, how many times do these agencies not develop?
Almost. They have a new policy. They require a pre-application visit. So they might screen some projects out or tone them down. But if you looked at the data, you would see that rarely is a Pell rejected. Because if you're a developer, you have that pre-application here. And the agency will say, look, I know you've got to be a little aggressive because the ZBA's going to be reviewing it. You're going to deal with them. But there's no way we can issue a letter on this. So the developer says, hey, no ticket. I'm not in the game. So I don't have any choice. I'm going to address the concerns that the Pell agency raised. So therefore, I'd say there have been few in the past, and there'll be fewer in the future. Alana? There was one in Reading, right? The classic Reading one?
Well, there was the one that I mentioned in Situate, right on the harbor, where it was too high and too dense. And I had another one that one of my towns sent a comment in on the PEL application, and the PEL was denied. But the reason why was because the town, when we did the title search, we determined that the town had an easement across the property for a sewer line, and there was another easement as well. And so, they didn't have the appropriate site control. So, certainly, unless there's a site control issue, unless there's something really dramatic going on, my experience has been the same, that the PELs tend to issue.
All of the obligations would be assigned to, assumed by, the homeowners association or the condominium association for a for-sale project.
There could be a perpetual
There's a
modification of the special permit.
Yes. I had to get a modification to a comprehensive permit that was 35 years old. Because I represented a developer who was doing another 40B project adjacent to this one, and we wanted to see if we could use that land for a second means of egress.
And what if the 10% quotient or
Doesn't make any
hadn't been met
difference.
at that point? Did they still modify it?
Right.
one other device, though, that the ZBA would have available in negotiating with the developer, and I did this just this past week with a ZBA and a developer, where the ZBA was concerned about future development. It's a fairly dense development as it is, with very specific patios and balconies and so forth. And in the discussion period and in the negotiation period, there was a very specific agreement reached that there would be no further patios, there would be no further sheds, no garages, no additions, no bump outs, no more impervious surface, no more structures. And so that will be a condition that's agreed to in the permit, but in order to make it stick, because as Ed said, of course, there can always be a modification, we negotiated a restrictive covenant that will be recorded against the land to that effect. So then that is enforceable in the future. And the only way that could be released, because it's an interest in land, would be through town meeting.
So that's interesting. And there's a classic case right now that's being litigated. In terms of the affordable units, obviously there is a deed rider that restricts the sale, restricts the resale price of that affordable unit in order to maintain affordability and perpetuity for that affordable unit.
We can require it in perpetuity.
Yes, yes, yes. Well, it has become the standard for rental developments that the unit shall be affordable in perpetuity, and it's supported by another SJC decision called the Ardmore case, where it said unless a specific term is included in the comprehensive permit for affordability, as long as that project doesn't satisfy the underlying zoning, the 25% affordability must be maintained.
And in regard to a project representing that it has clear deed, has there been instances in which the developer hasn't necessarily had a clear deed to the piece of property, and if that was in contention, would it be an appropriate time this period for the selectmen to make a comment to PHCD?
You can make a comment, but remember the project, one of the findings is of the Pell agency is that the developer has adequate site control. And there's a legal term that Alana can explain. If they have the color of title, which means there may be some questions about it, it's not definitive, and the ZBA says, we're not going to delve into that unless there's a very clear resolution to that. That's going to become the developer's problem downstream. And they'll have a condition that in the comprehensive permit, the developer must show that it controls the site.
Now, pre-2008, the 40B regulations provided that one of the things that the ZBA looked at was site control, but as of February of 2008, now that rests with the subsidizing agency through the project eligibility letter process. But it is still something, obviously, that the ZBA keeps track of, that the town keeps track of, and in the event that there's some issue about a lack of site control, then certainly I have been tasked, on a number of occasions to write to the subsidizing agency on behalf of the ZBA to say, gee, this property was just foreclosed upon and the developer has lost control. And there have been a couple of instances where, as a result of that, the project eligibility letter, after the fact, even after the comprehensive permit was granted, has been revoked. But the colorable title, yes, as long as they have a purchase and sale agreement, some way forward to obtain title, that is deemed sufficient for site control.
We're near the 7 o'clock deadline. Are there any further questions? Final question.
This is a little more general, Ed, but I wanted to ask, if you could just explain some of the history as to why in residential units, 100% of them count towards the shy, even though not all of them have to be affordable. I'm sure
The only rational explanation I've heard is that DHCD feels that there's a greater need for rental housing than for ownership housing, and that it wanted to create an incentive for developers to build rental housing. There have been numerous attempts to have both tenure types treated equally. Hasn't happened. I don't think it will happen.
And are there any 40Bs that have both rental and
Yes.
okay.
There's some hybrid projects, pretty complicated, but they're usually in separate areas. As a home builder, you wouldn't want to build for sale developments adjacent to rental housing. But you might say, hey, we can put the for sale over here and the rental here. So those hybrid projects, Littleton was a hybrid project.
Is that something we could negotiate?
You can try to negotiate anything.
And I just
Where the rental requirement is maintained by, what, a deed restriction?
A regulatory agreement. The primary control documents are the comprehensive permit itself, which is just like any other special permit. And your zoning enforcement officer monitors that. And remember, no variances in terms of building codes or anything like that. The building inspector's responsibility is to review the plans for compliance with code and compliance with the terms of the comprehensive permit. And then you've got the regulatory agreement.
Just to follow up, could a developer request to modify that in the future?
The regulatory agreement, that's entered into...
Whatever controls the continuation of the rental aspect of the units.
Sure, that you could say that we want to convert this rental project to a for sale project. I have worked on decisions where it says the unit shall be affordable, 25% of the unit shall be affordable in perpetuity, and the project shall remain rental in perpetuity. And developers represented by very good counsel, very aggressive counsel, have agreed to that because they have a pretty good understanding that the type of rental housing is never going to be that suitable for sale housing. Plus, at some point, if 40B went away, a town might argue that we'd rather see this as for sale housing. The courts don't like the word in perpetuity also. You never know what's going to happen. But you'd like to keep it as rental housing because you want to inch that 2.47% up.
If I had 10 houses that I wanted to donate to this 369 number, this shortage,
Right.
is there a boilerplate deed restriction that could be applied to those 10 units that would then make it so?
Sure.
How
Sure. As long as we could, you'd use that. The state has a program. It's called LIP, local units only, local action units, where the town has taken some local action, but not 40B, to allow those units. And then you would sign it would be you'd use the same regulatory agreement.
For how long?
For at least 30 years.
For at least 30 or at least 15? As I understand the LIHTC.
30.
It is 30.
Yeah, LIHTC is a separate animal. In order to get those LIHTC credits, you've got to, in order to score the points that are necessary in this very competitive funding, you've got to say they're going to be affordable in perpetuity. You're not going to get...
And there needs to be a marketing plan.
You have to own the project for 15 years because you get your benefit, have to hold for 15 years, you get your benefits over 10 years. Okay. And you have to have an affirmative fair housing marketing plan. Of course, they have to be sold to or rented to persons who qualify, and that is 80% of area median income. We done? Okay. It's again, I want to underscore how challenging it is for neighbors, for ZBAs, other town boards, and sometimes, to be fair, for developers to go through this process. 40B was designed to sort of simplify things. It remains still very complicated.
Thanks, Eric.
Thank you.
Lunch.
7:06.
Motion adjourned.
Aye.